In this video, we will discuss the concluding portion that we have left on Shufaa, and regarding that, the very filing of a suit regarding preemption or Shufaa, as it was expressed by Tabji as Tavali-e-Tamlik, and regarding that we'll discuss that filing of a suit by the preemptor according to Faji, as it is called Talabi-e-Tamlik, or the third demand. It is a mode of enforcing one's right of preemption. It should be filed within 1 year of the bandit taking possession of the property, or within 1 year of the registration of the sale deed. In case the preemptor is a minor, the suit may be filed by the guardian. When a decree is passed in favor of the preemptor, the right is vested in the preemptor from the date on which he pays the purchase price. In case of death of the preemptor, the suit may be continued by his legal representatives according to Shia and Shafi laws, but according to Hanafi law, the right to continue to the suit is extinguished, as at present the matter is governed under Section 306 of the Indian Succession Act 1925, so the right does not extinguish and it may continue by his executor or administrator, and the differences between the schools are of no consequences. And regarding Talabi Tamlik, we would like to discuss certain leading case. Azizar versus Haji Musaid in 1991, the Gujarat High Court expressed that as Muslim law categorically lays down that the right of preemption can be exercised only on the observance of certain formalities, so non-observance of any of the essential formalities will be fatal to the suit of preemption. And so also in another leading case, Aliman Nisha versus Sudhir in 1991, the Gujarat High Court held that if the right of preemption is not claimed when no demand is met, the right of preemption does not arise. And in the same way, in Ghulam versus Abdul in 1976, the Calcutta High Court expressed that the enforcement of the right of preemption must be preceded by observance of all the formalities prescribed by Muslim law. And in the last leading case, Muhammadi versus Mustaq Ali in 1958, the Allahabad High Court observed that if a sale deed includes properties which are subject to preemption and which are not subject to preemption, then the preemptor has the right only for those properties which are subject to preemption. And regarding right to preemption, we found the very important explanations and the views given by Professor Bailey in his digest on the principles of Mohammedan law, and that is in volume 2, and which were explained in page number 190, 505 and 506, where he explained the views of the Shias, Shafis and Hanafis on the continuity of a suit of preemption on the death of the preemptor during the pendency of the suit. And now we'll discuss regarding when the right of the preemption is lost, under what circumstances. So, by waiver, the first one, it is the preemptor. It fails to observe necessary formalities such as making demands or enters into a compromise with the buyer, such as when he agrees to cultivate the land, which is subject matter of preemption, then his right of preemption is lost. And the second one, when it dies after making both the demands but before filing of the suit, then also the right of preemption is lost. And the third one, when the preemptor joins himself as a co-plaintiff with a person who is not entitled to claim preemption, then also he lost his right of preemption. And the fourth one, when he releases the property for consideration to be paid to him, and when he refused to buy it, then also he lost the very right of preemption. And according to Mohammedan law, the right of preemption cannot be defeated or affected by any disposition of the property made by the bandee, nor even by the death of the bandee. So we have completed Shufaa or preemption, as already we have completed the first two parts.